Hi, my name is Brad Lakin, and I'm a Jones Act lawyer. Thanks for taking the time to watch this video. The video is about 3 sneaky tactics that your company will use against you when you're injured on the job. So the idea of this naturally is to avoid making these 3 critical mistakes. This is based upon my law firm's various experiences with representing injured maritime workers for many, many years. So let's talk specifically about the first sneaky tactic that we've seen based upon our many years of experience in this area of the law that the company uses to undermine those damages that you're entitled to under the law. And the first sneaky tactic that we see is the company will right away try to get you to see a company doctor. Many people ask me, well, Brad, am I required to see the company doctor? And the answer is no. And when I say the answer is no, I mean the answer is no. And you should never go to a doctor recommended by the company for obvious reasons, but let me explain how this works and how it in particularly applies to what I just discussed with you about the Jones Act. Since you have the burden of proof, it's your burden of proof to prove that your injuries are what they are. So when you go to a doctor, you want to make sure that you are seeing someone that's independent, who will, number one, provide excellent medical care to you, which is your primary concern, and second, if and when a legal action is required, they are going to be truthful, forthright in terms of the nature as well as the extent of your injuries. So you can see that if you're referred to the company doctor, this is vitally important to a potential future claim that you may have. I've seen bad story after bad story after bad story where a client or a potential client comes to us when they've treated with the company doctor for a period of time. And in some cases, the medical treatment that's provided is good care. That does happen from time to time. However, what we see is once the medical care is over, the doctor has the opinion that the particular maritime worker is capable of going back to work and doing their job, when in fact an independent physician who is treating that particular person would conclude otherwise, that they're just not capable of doing this hard work or hard labor on the waterways. So since it's your burden of proof under the Jones Act, if you go off to a company doctor, you're at the peril of the company, a doctor who is probably beholden to the company, or else they wouldn't have sent you there in the first place. So that's the first sneaky tactic that I have seen over the years that maritime companies always use. So you should always go to an independent doctor of your choice, someone's referred to either by your family physician or by a neighbor or someone you know, someone you like and someone you trust. The second sneaky tactic that we see is that the company will immediately try to get a written or a recorded statement from you about the specific incident. They may suggest to you that you're required to do so. They may suggest to you that your failure to do so will result in discipline. In 99% of the cases, that is not true, unless you have a collective bargaining agreement that requires you to do so. That's very rare. You would have known about it if you are one of the few maritime trades in a union. But in any event, you're not required to give a statement, and you should not give a statement. You should not do that until you've consulted with an experienced Jones Act lawyer. Someone can walk you through the various steps, the various pitfalls to giving a statement. Now, some people say, well, if I just tell it the way it is, that's the way it is. Well, that is true. And of course, you're going to be 100% honest in giving your testimony. However, if you fail to basically mention some detail that you would consider to be otherwise insignificant, but later it isn't significant, they will suggest that you were less than honest. In addition, based upon a particular scenario, what is occurring, You may not have the knowledge and the experience and expertise to know what specific standard perhaps that a co-employee of yours failed to follow that contributed to your accident. So it's vitally important that you do not fall into this pitfall, one of the company's sneaky tactics, number 2, which is getting a recorded statement. And the only intent of the company to get a recorded statement from you is to undermine and get admissions from you that either do away with your claim or eventually provide facts that undermine your eventual claim or the monetary damages that the company has to pay you. The third sneaky tactic is where the company tries to convince you, suggest to you that you will either be disciplined or treated adversely for seeking legal advice from a qualified Jones Act lawyer. This is not the case. In fact, the federal law strictly prohibits this. You are allowed to get legal advice. You should get legal advice, and that's confidential in nature, which the company doesn't know. It never hurts you to go see a qualified Jones Act lawyer early on is absolutely critical so that you avoid not only these 3 common pitfalls, but also others. So you're entitled to see a Jones Act lawyer. You should do so so that you don't make these mistakes or other common mistakes that we see every day. So just to basically summarize what you need to do to avoid these 3 sneaky tactics is, number 1, don't give a statement until you've talked to an experienced Jones Act lawyer. Number 2, see a qualified physician of your choice, not the company's referred physician. And 3rd, seek the advice of a qualified lawyer. You have a telephone number here on the screen. Feel free to give us a call at that number 24/7. We'll answer your calls, provide a free legal consultation to you, or you can get your question answered by filling out the form below. Thank you.